I think we have material for lots of questions. And I'd like to start off picking up from what you said. Your opinion is clear, but I'd like to hear the views of the other members of the panel on whether, even if full uniformity is not desirable or achievable, whether we could achieve some more uniformity, at least in the international arbitration arena, not on domestic cases. We could discuss a double standard like they have in Switzerland, for instance. So my question is, some people believe there's no need to change the New York Convention to provide more grounds for more uniformity. Some people say that Article 2.3 of the New York Convention already provides for a standard of a prima facie review and not full review. They base this argument on the fact that not referring the case to the arbitrators is the exception, not the rule, and that the convention has an overall pro-arbitration approach. I think your answer is that you do not think that the New York Convention provides for that kind of prima facie standard, but I'd like to please confirm if that's the case, and I'd like to hear the views of the other members of the panel, whether we could draw from the New York Convention as it stands more grounds for further uniformity.
Do you want me to start?
I mean, just
yes, that is my view. I do not think that the New York Convention prescribes the standard review in those states, because I think if you argue that it does, then there are certain countries that are in breach of their obligations under the New York Convention. And certainly as an Englishman, I would resist that argument.
I think that uniformity could provide more legal certainty to parties in the international arbitration. I really think that it could be, because like when you submit to arbitration, you don't know exactly how the control of the validity and of the arbitration convention would be perceived, and it's going to be perceived in a different way depending on the jurisdiction. So therefore, I think it would influence when you are writing the convention, and I think it would be better, but maybe just a slight disagreement.
Oh, no, I don't disagree with that at all. I agree, in a perfect world, that's what would happen, just to be clear. I just don't think that's achievable.
Yeah.
Well, I think we've come a long way over the past 60 years in what concerns uniformity and harmonization of the law in the area of international arbitration, starting with the New York Convention and then the UNCITRAL model law, and that has clearly facilitated international trade. So uniformity and harmonization, as Chris puts it, are in itself a good thing. But the point here is to what extent can we bring this uniformity? Is it possible to have uniformity in respect of these aspects? The issue of competence is a particularly delicate issue because we are dealing here with the interaction between state courts and arbitral tribunals. And the way national legal systems regard the relationship between arbitral tribunals and state courts is not the same everywhere. It differs very widely, and it differs for very deep reasons. How free should parties be to decide that they opt out completely from state courts' jurisdiction, including in what concerns the assessment of the validity of the award? France has decided that in international arbitration this is possible. You may just skip the jurisdiction of state courts. But this is something that other countries are not prepared to accept. England has not been so thus far, although it is a very important arbitration center worldwide, and other countries are not either. So although I'm, as a matter of principle, in favor of uniformity, I think everyone who deals with arbitration probably is to a large extent, because if it were not for these instruments that I've mentioned, arbitration would not have developed worldwide as it has thus far. I'm afraid that there are certain issues in respect of which uniformity is really a dream so far.
Let us take a couple of questions from the audience, if there are any.
André.
Yeah?
Imagine you are the drafters of the new Arbitration Act of your country. So would you allow? Thank you. So my question is, it's not about the current law, but imagine you are the drafters of a new Arbitration Act of your countries. Would you allow parties to completely waive the judicial control over the jurisdiction of the arbitral tribunal? I think Professor Dario touched this issue a little bit, but I'd like to hear from all of you. Thanks.
Thank you. Who wants to start off? Danielle?
So I think from my perspective, if you want to have the ability to waive review of scope issues, for example, or other jurisdictional decisions along those lines, then I think that makes a lot of sense if that's what the parties want to do. But at least looking at some of the cases coming up in the U.S. context, if there's a fundamental question about whether the parties even agreed to arbitrate in the first place, I think it's fair to ask whether they should have to arbitrate that question or whether, in that case, they would be entitled to have a court make that decision, whether you want to say it's before the award is issued, after the award is issued, in parallel. But I think prohibiting or allowing parties to completely take jurisdictional decisions away from the courts may be a bit too far in the direction of uniformity from my perspective.
You want to answer?
But you're not talking only about competence, right? You're talking in general, like the right of waiving the action for having the award null and void from
Can be both.
grounds.
Can be both. I talk about the jurisdiction or either about the merit.
But I think you'd be more focused on the pre-award competence issue, right? The third aspect of the principle that Chris mentioned.
I would say so. I think that like the autonomy of the parties is the cornerstone of arbitration. So if they can submit to arbitration with specific rules, and if they really wish to waive the right for having the court supervising the arbitral decision, why not? I really understand. So because otherwise we would even be against the principle that enables arbitration to be valid, which is already a waiver of the right of seeking judicial support. So I think that it comes from the same place, this right.
And in a post-award stage?
I'm sorry?
In a post-award stage?
Yeah,
so
exactly. Waiving the right of having right for seeking judicial control of the award. I think that it would be possible if the law provides so, and if the parties agree to do that, I think it would be possible.
If I may, just before you do, I would not. I think the prima facie test strikes a nice balance between tackling the problem of relying on invalid arbitration agreements on the one hand, and on the other hand, the problem of having frivolous challenges against arbitration agreements. I think it strikes a very good balance. Yeah.
So if I was writing my own law, what a joy that would be. Post-award, no, I would not. I think that takes it a step too far. I think recognizing that in a post-award world, you're going to be trying to enforce anyway. So the jurisdiction question is going to come up in the enforcing court. And I think it'd be very difficult to have a situation where you waive your right to resist enforcement on the grounds of jurisdiction. So I think there's value in having a court that could hopefully dissolve that question for you in one court rather than 10 different states. I think pre-award, my view would be, entirely in favour of tribunals always having their own jurisdiction. They will always continue, and I think they do in most places. I find it very difficult to be in a situation where the parties can agree in advance that a court shall never have jurisdiction to decide whether it can hear a claim, for the simple reason of, well, that issue, whether a claim is outside of the arbitration agreement. Someone says it doesn't cover by our agreement, but then you've excluded the court's right to look at that. For me, I struggle to see how that can work as an absolute prohibition on courts.
Even in the terms of reference?
Exactly.
In the terms of reference?
Even in the terms of reference?
Means once the dispute arises and you know it's
my
within
doubt
the
is
scope of the
which fundamental right of the parties would the parties be violating in case they wish to waive this? You know, I had my background in France, right? That's why I have this liberal approach. But I mean, if like arbitration is all about party autonomy, and I heard, I was in ICC conference in Miami, and I heard from Eduardo da Silva Romero that arbitration is a product of our fighting. We have fought to have arbitration as an alternative to judicial system. So if the parties want to submit themselves to a total, complete different system, you know, without having the resource to the judicial courts, why not? Like, you know, that's my view. But.
Yep.
May I? Well, André's question is a question that we've asked ourselves in Portugal when we drafted the Portuguese law on arbitration back in 2011. Should parties be allowed to completely waive judicial review of arbitral awards on grounds of serious defects of the arbitral proceedings or of the award? And the conclusion we came to was that we should not. Of course, Eleonora says, well, if it's the parties' will, why not? Why shouldn't parties be allowed to do that? Well, but the problem is that if you allow such a waiver, then you can ask what will be the effect of the arbitral award. Should it be enforceable directly, or is this just something that stems from a party's agreement, but in order to enforce it, you have to have an exequatur from a state court? That's what happens in France. I mean, you can waive everything in France, but in international arbitration, but the award is not directly enforceable. You have to go to a state court to have an exequatur decision. And we've decided in Portugal that it would be more important for parties to have an award that is equivalent in its effects to a state court's ruling, so it can be directly enforced. And that you cannot have unless you have some degree of control by state courts on the award. So giving parties total autonomy has a price, and that price is that the award you get in that case does not have the same effect as a state court's ruling. So you have to choose what you want. Either you want something that is totally the product of the party's will, and they can waive whatever judicial review they wish, or you want to have something that is equivalent in its effects to a state court's ruling. We have opted for this second possibility, but in order to make this possible, some type of judicial review of arbitral awards had to be instituted that cannot be waived. So that's the middle course we try to strike here.
Just a last comment. Sometimes I think that everybody thinks that there is sort of superiority of the judicial system over the arbitration. I think they're just two different systems with their own rules. So I don't see why the judicial courts and system would be more legitimate to analyze certain commercial issues among certain parties. That's my premise. That's why.
We have time for one more question.
I would not say differently.
Please, go ahead.
Regarding so Chris said that there's general uniformity on the enforcement side of it, right? That
it's generally accepted that courts will review de novo the jurisdiction of the arbitration tribunal. Now, I was wondering if this has been tested in those jurisdictions where for tribunals seated in the jurisdiction, there's much more deference given to the tribunal. For example, in the first options case, or in France, where the parties can waive the right to go to the court. So I was wondering if in the enforcement side, so let's say a tribunal seated in London, if you try to enforce in New York, if the courts in New York will apply that first options test and give much more deference instead of reviewing de novo.
That one is for you, Danielle.
Yeah, thank you.
Sorry.
Yeah, so my understanding, I haven't been involved in enforcement of foreign arbitral awards in the US, is that the first options test would apply in the case of review of decisions that were issued in the United States and where the court is involved in sort of the first level review, but when it's enforcing foreign judgments, it would apply a de novo standard rather than the first options test.
Thanks.
Okay, we have time for one more. Yep.
Hello, my name is Diego. I come from Lex Finance. So I would like to agree with Christian on the fact that the uniformity of the application of competence principle should stay like a dream. There are some dreams that should not be pursued. Some dreams shall stay just as dreams. But at the same time, I understand the obsession of lawyers to pursue certainty, their high aversion of risk, and how they feel more comfortable with certainty. But having said that, I would like to raise another particular issue where might be considered a dream, which is public policy as a condition or requisite to set aside an award. So I would like to understand the panelist's opinion on regard how public policy can be uniformed in international arbitration, and see if this would be considered another dream that can be pursued by the arbitration community.
Thank you. That's a very good idea for next year's conference.
Or at least the coffee break.
Or at least a nice conversation over coffee. Anyone
But
wants
it's definitely a dream. If competence uniformity is a dream, public policy is, I don't know, fantasy.
But like talking about France, I would quote a professor, French professor, Catherine Cassegedian. She says that transnational public policy is like a white elephant. When it's in the room, you realize it's in the room.
All right. With the image of the white elephant, let's finish this up by thanking our panelists. Please join me. Thank you very much.